Hi, this is Kurt Barone, and welcome to another edition of Fire Law Roundup.
Brad, we did miss one.
did?
The New Jersey case, and I thought you'd be really interested in that one because I think it sounds a lot like a lot of the cases that you end up dealing with. But the New Jersey.
Yeah, give me a second. I have my notes. Hold on a second.
Yeah.
I'm going to step away.
Yeah. Well, I'll start going through the facts here, but we've got a volunteer firefighter in the borough of Allendale who claims that he was duly elected. He was a captain or first captain with the volunteer fire department. And under the regulations or under the ordinances, the township ordinances, he should have been approved as I think it's an assistant chief.
As an assistant chief, right? The commissioner should have approved him.
Yeah. So what are you?
Yeah, I can't find my notes, but I got it pretty well memorized. So he claims that he's 25 years old, right? Which is the first thing, because I think at least under federal law, you can't make an age discrimination claim unless I think you're 40 and above.
Right.
So he claims that, and he claims it's because he complained about something that he's being retaliated against and he's not being promoted. FYI, I think he's going to lose, by the way. But and he just makes his claim that the reason you're not promoting me, Board of Fire, where they always, he said, you've always approved everybody. Now, I don't think that matters because it's still discretionary. In New York, I don't know about New Jersey, but I will say New York and New Jersey laws are very similar. In New York, you don't need to give a reason. So they don't have to give a reason. I'm sure here too, it just can't be a discriminatory reason. So age, I don't think is going to fly because I think you have to be 40 and over, or at least federally, and most states mirror that. And retaliating for having made a complaint. And he said, and this is weird too, they said, well, there's also another person who apparently isn't a party to this, who was a witness, who's also being retaliated against, who also isn't going to get promoted.
Yeah, so there's two elections. As I get it, he's a first captain. He's going up to assistant chief. There's another firefighter who's now going to become the captain, first captain. So there's two people who are being blocked because they said we're not going to authorize either promotion.
Yeah, and this is just such a hard case, but he's basically making a retaliation claim, right? He's saying I'm being retaliated against because I complained about something. But it is a very hard case because there's not a collective mind. And I use that phrase a lot. When boards make a motion and approve an action or disapprove an action, like here, we're not going to promote them, there's not necessarily a collective mind. So one person could say, listen, I think the kid doesn't have enough experience. He's 25. I'm not going to make him a chief. And that, by the way, would fly in all instances. Right. Another person said, oh, I'm really pissed off. I'm retaliating against them. Okay, well, that's one member of five. Now, I've had this case, so I can discuss it. That's one member of five, let's say, that's absolutely retaliating. But the other four say, we just don't think he's right for the position yet. He's too young. He's 25, never seen a real fire. I'm making this up, right? But he's a volunteer. So also, what are his damages? But nonetheless, if one of five or two of five are not the majority mind, then has the board discriminated? So the cases I found on a separate case that I had is no, one of five may serve as some evidence that there's a impermissible reason to deny someone, but it's not evidence. It's not convincing evidence of the reasons for all five. So he's going to have to show that 3 out of the 5, or however many on the board, I think it's 5, but that a majority of the members had impermissible reasons. That's very tough to do. How are you going to do that? And by the way, all they have to say, as soon as I saw 25 is, he's too young. Now, look, you could fight that. Well, the last one before him was 22, and this is 23.
And some states allow any sort of age discrimination. I can't speak for New Jersey, but there are states out there that expand the protection for age discrimination.
But inexperience isn't age, right? You don't have the experience.
Absolutely.
If you were 60, you wouldn't have the experience because you've only been doing it for 5 years or 3 years. Now, again, you can refute that, right? Some people, and I always say, being a jerk is not a protected class. So they may just not like him, right? everybody always has something that they said, I did, it was protected activity, and they're retaliating against me in this way because I did something. So I stuck up for so-and-so, I was protected, that was 2 years ago, and now you're discriminating against me in retaliation. Maybe they are, maybe they aren't, but proving it is going to be very difficult when it's so easy to say, I'm sorry, we have a clear reason, no matter what, that you would not have gotten this position anyway. You're too young, too inexperienced, too whatever. People don't like you, whatever it is. But it is a very interesting suit. I have had a number of people call me, I will tell you, probably every year come January where chiefs don't get appointed. I probably get, I'm not exaggerating, no fewer than 10 or 15 cases in the month of January where commissioners refuse to appoint somebody or confirm their election to chief. And I say, what's your reason? And all the time, frankly, we just can't stand the person. Any reason why? Nope. It's a white male. There's nothing you can come. They're like, sorry, you have nothing to do. Yeah, there's nothing he can do, right? You can't, you didn't get the position. Oh, well, not everyone likes you. The same reason not everyone gets hired. I just didn't like you. I don't think you're right for the job. As long as it's not a protected class, female, age, race, gender, they can deny you for any reason they want. So proving that there was a discriminatory intent that made up part of that decision, almost impossible. So that's where we are.
Yeah, interesting case. I kind of figured you handled quite a few of those. And
I do, and for some reason I left it off my notes, but I have it somewhere. But yeah, it's a great case, and he's going to lose. But I look forward to the decision in that, because I think, but this discovery and everything is going to go on for a while.
I always wanted cases like this. Somebody comes to me, and I get calls from all over the country, and I can only handle cases in Rhode Island and Maine. Those are the only two states that but I get calls on cases like this. But I also try to speak honestly with these people and say, look, you're a volunteer. Maybe you get a little bit of stipend here. Are you going to invest $20, $30, $40, $50,000 bringing this suit? Because you're suing government. Yep. They've got insurance. They're gonna do everything they can to make it as costly as they can. I envision this now being removed to federal courts, and now you're going to have to jump through those hoops if they can't get it dismissed immediately. Is it really worth 50, maybe even more? Right. To you? Because most attorneys are not going to take a case like this on a contingency basis. It's just not the kind of case that you could, you can't. So is it really going to be worth it to you to do that? So in this case, apparently with this firefighter, he felt it was worth it, and he got an attorney, and, good luck to him.
Yeah. And I've had that conversation with clients as late as probably last month that I'll do it, but I'm telling you right in advance, I think we're going to lose. If you want to pay hourly, the law in a lot of these. So people understand discrimination claims. A lot of laws provide that if you win, even if you win $1, we'll pay your attorney's fees, right? Reasonable attorney's fees. So that is done to encourage for this purpose. The law says, listen, you're probably not going to get a lot of money, but we don't want your rights not to be, put forth and enforced. So we'll pay the attorneys, or we'll make sure the losing side pays the attorneys. That sometimes is a good enough incentive to get the attorney to do the work. It doesn't work for me. I'm too busy to hope that, okay, I won you $1, but I get, $50,000. To me, there's something wrong with that theory. I get it. But maybe this is one of those instances where, look, if it is a retaliation claim, maybe it's under one of the many laws that provide the attorney's fees.
But then you got to win.
I would take.
But you got to win. And they're gonna make it as hard as they possibly can for you to get to that actual payday. So.
And what you got to proving a collective, and I'm assuming the law is the same in New Jersey, but proving that collective mind of a majority of the commissioners were all about the retaliation. Boy, that's tough. A well-coached attorney is simply going to say, I'm sorry, wasn't very experienced, or I just didn't like the guy.
Yeah.